Well, let's get started here. And again, welcome everybody who's joined us. My name is Kirk Hanson. I'm the Director of Forestry for the Northwest Natural Resource Group, and welcome to our November Fireside Chat on the topic of estate planning. Coming to you from my living room, I have my active fire going behind me here to make this Fireside Chat fully legitimate. And this topic is really personal to me, as my family has just gone through, or is still in the process, kind of the tail end of going through a very rigorous estate planning process. We thought we had everything in place. My parents owned a couple tracts of forest land. It was always their intent to pass that as part of their larger estate down to myself, and they had a will and an estate plan in place, and it looked like everything was hunky-dory. And then my dad somewhat suddenly passed away in February, and almost became very real to us. And as we started digging into the estate plan that they had in place and the will they had in place, we very quickly realized that not everything was as in place as it should have been to effectively value the forest land and smoothly transfer that down to the next generation. I have two sisters as well, and so we've been working with Cynthia Worth, who is joining us this evening from the Worth Law Group, to kind of rework our estate plan and make sure that the various assets that my parents had passed down smoothly to us, and in particular the forest land is recognized as a unique asset. And I'd say if there's any little bit of word of wisdom for myself to everybody else, it's that you understand that forest land or farmland, land in general, is a very unique asset as compared to stocks or cash or other types of assets. And it's not my impression that every attorney understands rural forest land as an asset. So we are very fortunate to have an attorney right here in my hometown of Olympia that not only understands that, but is a forest owner herself and a farmer herself. And so personally gets this, understands who we are as small woodland owners, as well as the unique qualities of forest land as an asset. So with that as an introduction, I'm very, very happy to have Cynthia Worth joining us. And the way that these Fireside Chats typically go is that we'll have, Cynthia is going to talk with us for about a half hour or so and share with you some of her best advice about how you as small woodland owners should think about your forest and think about estate planning. It's a rather unenviable task because it's an enormous topic. So we've only given her 30 minutes to discuss that. And then we're going to open it up. I know a lot of people have sent questions in to Alex. If you have questions during Cynthia's presentation, you can type them into the chat function at the bottom of the Zoom screen. Alex will field a few of those questions to Cynthia. And then I'd like to open it up, and you can ask questions directly of Cynthia, and hopefully we can have a little more of a conversation back and forth. And then we will have a tight ending at 8:30, so folks can get on with their evening. So I'll leave it at that. And again, once again, Cynthia, thank you for joining us, and appreciate taking time out of your evening to talk with folks.
Well, and thanks for having me, as I have a coughing fit here. Well, apparently I was outdone. I had my little fire here for my fireside chat. My staff had gotten me a little fake fireplace for my office last year for Christmas, but I see Kirk has a real one. So, but great to be with everybody tonight. What's difficult for me is I'm a big talker. And so I'm going to try to cover as much as I possibly can and answer questions. Lots of times, the best way we learn is from great questions, as opposed to me, just talking at you. And Kirk, thanks for pointing out that I am a bit of a farmer. I I do feel in my heart of hearts that landowners and farmers are different people. We have a tendency to value things a little bit differently than, say, stocks or bonds. And I tease some of my counterparts that practice in Seattle, like, well, you can't do anything fun with money. I mean, down here, we've got, farms and dairies and timber holdings, and things can get real interesting. So that being said, I have had the opportunity to look at least the questions that have come in so far. So I'm going to try to weave some of those into the things that we're going to talk about. So just to launch right in, the first thing I want to talk about is what exactly is the estate planning process, and why do we use those words as opposed to, hey, I need a will? And I want you to know that estate planning is simply the name that we call undergoing getting your affairs in order. And right now, there are no two states in the entire United States of America that treat death the same. And that means that it's very difficult for any of us as a consumer to hop on the internet and find out, well, what's a healthcare power of attorney, or what's a revocable living trust, because each state treats that differently. But the process is the same. And estate planning means that you start by ascertaining, and in our office, we call that legal proof of every single solitary thing you own. If you're not undergoing that level of disclosure and getting information together, then it likely is not going to be a successful estate plan. And personally, I have not ever, in 30 years of doing this, ran into anyone that didn't forget to tell me about something that they own, or the fact that maybe they had a burial plot in Kansas that a family member had given them that they have no intention of being buried in. But we start by inventorying the assets and legally ascertaining what do we own. Now, why? Why do we do that? Well, we need to know what we own to be able to tell the world where we want it to go and how we want it to pass. But very importantly, there are dozens of ways to pass an asset when you die. A couple of little examples would be a will, or something like joint tenancy with right of survivorship, if anyone's ever heard of that. That's a method of owning something. Let's say Kirk and I own a piece of land and it's joint tenants with right of survivorship. It means if I die, no matter what my will says, it goes to Kirk. So there's other ownership methodologies, like having an account with a POD, which stands for payable on death. Okay, that's not controlled by someone's will, or a transfer on death. Or some of you might have things like retirement plans or a 401k or an IRA, which cannot pass according to your will. That passes according to a legally binding contract that you sign with, like, the retirement company. But my point here is it's a quagmire. It's complicated. And the starting place to ensure you get a good plan is the exacting process of figuring out what you own and how it's titled, so that you can bring this all together to accomplish your goals. So after we inventory our assets, what are the basics of estate planning in Washington? And why is Washington, and in what ways is it unique from other states? So first and foremost, every Washingtonian needs 5 documents. Those 5 documents, briefly, because I could talk for 8 hours just about those documents. The first one would be a document entitled Disposal of Remains. This is a document that says, for example, I, Cynthia, am going to be cremated. I want my ashes spread in Lake Chelan, and I put Susie in charge of disposing of my body. This is an important document because, especially if you're to be cremated, it sets things in motion automatically, as opposed to getting required signatures and the delay that that can have in cremating you or disposing of your body. Quite frankly, when families experience delays like that, it's just not fun to go through. And I think of your estate plan as your largest gift that you're leaving to your family, which is not a mess. Okay, so after our disposal of remains document, we have our second document, which in this state is called a healthcare directive. In other states, it's called a living will. And it is a document that is a statement to the world that says, if I have been taken off life support. So that's already done. If I've been taken off life support, give me food and water artificially, don't give me food and water artificially, or give me artificial water, but not food. It's very straightforward in the way that it presents, but I'm sure we can all appreciate that that is a very difficult time in life. And it's a wonderful gift to be able to tell your family, you know what? We don't get to ask her right now, but she did tell us in this document, don't keep her alive artificially. She wouldn't want that. So another critical gift to give your family. And again, in Washington, we call it a healthcare directive. And it also requires 3 witnesses that are unrelated to you and that they swear that they're not standing by to get a kidney from you. I'm not joking. You actually, the witnesses have to sign that they're not getting organs from you. So interesting. That was a change after our assisted suicide laws passed. Okay, moving right along. The next 2 documents we probably all have familiarity with. Those are our financial power of attorney and our healthcare power of attorney. And with the advent of a law that I'm sure most of us are familiar with, which is HIPAA, these documents used to be combined, and we used to have one power of attorney and it covered healthcare and financial. We no longer do that. They're separate documents. One speaks to, here's what I want done if I'm alive but unable to manage my affairs. And here's the power I give somebody to make these decisions for me. The same is true on the healthcare side of things. A little aside is these documents that are effective while you're alive and allow other people to make decisions. This is an area where you cannot put multiple people in charge. As you can imagine, if I was checked into Providence and they had to decide whether or not to take me off life support, they're not going to take a poll on the people that I've named on my healthcare document. Again, it's an area where you name a person, you have a primary, a secondary, and then a backup. In my experience, you must have backup persons because life happens. And if I'm married and I simply put my spouse as my power of attorney and my spouse dies, not only do I have to deal with losing my spouse, I have to update my documents immediately. So I'm kind of sitting there with no documents. That's not a good plan. Okay, our 5th document is what we call a will. And the thing I like about Washington is everybody knows what a will is. And that's what we use in Washington. This is a really important concept. Washington does not make its money off the business of dying. Where if we were in California or we were in Oregon, 2 of the worst states, they legitimately make money off the business of dying. I'm sure many of us have heard about horrible probate fees. Well, in those states, a percentage is allowed to be charged for the court, the attorney, and the person in charge. Well, in Washington, the fee to go through probate for all of us is $230. We all pay the same fee. And this state is not an area where you actively avoid probate. I want to ask you to please also consider the following. When we do our wills, we're kind of all about us and thinking about us and what we want. But the person that you place in charge when you die, which used to be called the executor, executrix, is now, we call them the personal representative. They are stepping in and they are handling your estate, which is not a fun job, no matter how you slice it. And it is about who can later come back and sue them or question their actions. And the probate process in Washington, when it's over, there is a court order that goes to the person in charge and says it's over, nobody can sue you. So sometimes we look at it from, well, I don't want to go through probate. Well, you're not going through probate, you died. What we want is an orderly process to get your assets inventoried, your bills paid, and get your assets to where we're supposed to. So one of the points that I want to make is that we do not automatically, as Washingtonians, dismiss wills and the probate process. I'm going to also use this as an opportunity to talk about revocable living trusts, because we've had a lot of questions about that. And please notice that that was not one of my 5 critical documents to have in Washington. As a just general rule, this is not a state where everyone needs to have a revocable living trust to avoid probate like you do in California or even Oregon. Revocable living trusts can be incredibly expensive. They can add an incredible amount of complexity that many times is unnecessary. And we do not create revocable living trusts for just the sake of having a revocable living trust. We need to have a good reason that it would be unique to each and every family as to why we might create a trust. A significant difference in the probate process and the trust administration process is the trust administration process has no end, and a person who is in charge, which is called a trustee, can be sued for a variety of different things that they did wrong or are alleged to have done wrong in settling an estate for a very, very, very long time. And if you're the person in charge, and let's say, I'm one of 3 daughters and I'm in charge of an estate. So my sisters get their inheritance, but my inheritance, if I am using a revocable living trust and don't go through the probate process, I have to sit here and wonder when my sisters are going to come and sue me, because 5 years after the fact, they could decide that they're irritated with me. And I mean, how would I even defend myself? I don't even have any money left in the revocable living trust. So this is just an example of how where you live, where property that you own is situated, plays into your estate plan. Which I want to reiterate that point, when we use the term estate plan, it's trying to encompass everything we own, all of our goals, and accomplish those. If we don't disclose and we don't talk about what we own, how do we know what the right plan is for us? So again, I want to really hone in on the difference between swinging by an attorney's office and saying I needed a will and drafting one up, and no correlation between what does a client really own. What do we really need to dispose of? And in 30 years, I've never had the same family twice. Every family, every person is unique. Everybody owns different things. And you want to examine what you own with your estate planning attorney so that you can get options and even know what's available to you. And again, I cannot hone in on that point enough to make sure that we're looking at it big picture. Okay. So we all learned that we need 5 documents in Washington, and we can build on those documents, but those are our basic documents. And we also learned what the term estate planning, really means. So I've also been asked the question of what are the consequences of no estate plan? And I want you to know that I feel that the consequences have gotten more and more onerous of failing to plan as our society becomes more and more complex. Getting through COVID and assisting families that lost somebody in and of itself was a devastating experience for people in the estate planning world because it was a lot of death. But what was really horrific was trying to communicate with organizations, get funds released, get money moved from a husband to a wife. I mean, really challenging. But are we not all in agreement that this world has gotten crazy complex all of a sudden? So failure to plan is in and of itself a plan. It's a plan which is, I don't care, I'm dead, they're just going to have to deal with it. And there's a lot of evidence out there that it typically doubles your cost in settling your estate. What I find in failure to plan is that oftentimes individuals do things that piecemeal together. Remember when I mentioned that I could have a 401k or an IRA and I do a contract and I tell them that I want that to pass to Alex when I pass away. Well, that is a plan. I mean, that's where it's going to go when I pass away. But what about the coordination and who would pay the taxes on that? These are just examples of why we've got to pull everything together. Or what if Cynthia does a will and I say, leave everything to my daughter, and I find out I didn't think about the fact that I've got life insurance, which only passes by contract. And then I have IRAs, which also pass by contract. And here I am thinking, well, I've got a will and I've got a plan. Well, it's not going to work because I didn't coordinate those things to work together. But again, that comes back to what the meat of what we call estate planning. I want you to also think of the best gift you can give somebody in your family members or whomever it is that you're leaving your estate is to be well planned. And that in and of itself is just a wonderful, wonderful gift. And in one of our questions that was raised, I want to also give you the concept that once you go through this process, you've got everything nailed down, what you own, and you get your documents in place. First of all, you should feel like, woo, I feel great, because it's a load off and you know, hey, everything's going to work. Well, then from that point forward, you just update that as you need to. People don't have to start over every time that they want to update their will. We in our office think of our clients as long-term relationships. My favorite phone call, a new grandchild was born. I just bought 100 more acres of timberland. Well, we shouldn't have to redo everything. Those are just adding to our existing estate plan. So sometimes you can think of it more of a life adventure where you just keep on top of it and you only have to undergo the horrible part of figuring out everything you own once. And I think that can be especially fun if you're somebody like me, where when I was younger, every time I got one of those $1,000 life insurance policies from a bank account I opened, I signed up for it. So I realized that I have like $8,000 life insurance policies. You know what? That $8,000 that might happen is going to be an awful pain in the rear from my family if I don't coordinate that. And if I didn't even tell them about it because I forgot, again, I'm just kind of leaving problems for them. Okay, I have one other really large topic that I at least want to touch on before we break out into our questions. And that is a great question that has been presented, which is, how do timber owners or small landowners differ in their estate plans from other people who don't have those types of assets, and what are their unique tax consequences? And I think that that can be summed up into one rule of thumb for all farmers. I don't care if you're farming cranberries or timber or cows. You think that you can't afford to pay attention and everything you own is worth 50 cents. If we plan and we are not accurate in our assumptions of what the value of our state is, we can get blindsided by estate taxes. Currently, each person is allowed to leave $2,193,000 as a Washington resident to anyone they want. So it's important, if I think my timberland is worth $500,000 because that's my tax assessed value, and I plan based on that, but in reality, my timber farm could be a housing development and it's worth $3 million, I now have a big tax problem. And again, I find that farmers, it's just in our genes that we do not value things at the highest and best use. We think about it as it sits and as we use it. Why? Well, because we're not converting land into money. That would be our city counterparts sometimes. So on a daily basis, I have someone come into my office and tell me they are worth some low amount, and they show me their tax statement, and they show me that they're in open space or farm ag or timber, and they try to tell me that's the value. Okay, so when you die, your property is valued at the highest and best use. Tax assessed value is no indication of fair market value. That is a matter, that is a certainty within the IRS. And I would like to see, by show of hands, how many of you will sell me your timber property today for tax assessed value? I don't see anybody's hand up, but yet we all complain about it, right? Okay, now there's a difference between tax assessed value for timberland and highest and best use in the concept, okay? When someone dies, land is appraised, and maybe the highest and best use is timberland. But that doesn't mean we just get to automatically use that tax assessed value. We actually have to go through the process of appraising our land. And ultimately, that appraisal goes to the IRS when we die. So it's pretty important. And again, our big shortcoming as farmers is saying, I don't have a tax problem. I didn't do any tax planning in my estate planning because I didn't think I was worth that much money. And quite frankly, $2,193,000 adds up really quick these days. By the time, somebody has a house, maybe some retirement, I mean, it's just amazing. You can get to that $2,193,000 really quickly. And when you are near that amount, you really need to start taking taxes into consideration as part of your estate plan. So I wanted to make sure I got in the ability to talk about what is the difference between tax assessed value and fair market value. I see that I am already 2 minutes over when I should be transitioning into our questions. And I got a lot of questions here. Can you guys all see them, or is it just me? I don't know how you do the view.
Oh, the questions coming into the chat. I think some of them are public, so people should have been able to see them rolling in.
Okay. Okay.
And I got one privately too. So,
Okay.
yeah.
And so I don't know, you know, and feel free, anybody, if you want to raise your hand too. I mean, I love to talk to people and figure out what are your questions, as opposed to me kind of talking at you. So I see one, I'm just going to hit some of these easy ones. Can a conservation easement be reversed? Sounds like somebody's not happy. You know what? I think there's a lot of people who would say no, but I also am a firm believer in a really important concept, which is where there's a will, there's a way. And I don't want to say as a matter of course that in every circumstance you could never fix or get out of a conservation easement. And there are individuals who have more expertise in helping someone navigate to a better level of satisfaction with their conservation easement at a minimum. So whoever is asking that, want you to know, never lose hope. Okay. Now, if somebody is on the other side asking, hey, is there a way for me to permanently lock things up that can never be undone? I feel that a great, well-negotiated, not off of the shelf conservation easement is what a family would want to do. Where I like to caution people is that I don't know that everybody realizes that a conservation easement is something I enter into with someone and I negotiate. And so I can say what it is I want to do, and I don't have to accept what my offer is. Briefly, our family has 125 acres on the Satsop River. And so our conservation easement, guess what? Me and every family member is going to be able to float the river from now until the end of time. And I want to be able to go down to the river. I want to camp. I want to have a fire, and I want to have my friends over. And you know what? And I might need to drive my Kubota car, which is a fancy ATV, because it's 125 acres. And I realize I'm getting older and can't walk the whole property. So guess what? We each have unique needs with the conservation easement. And I urge you to get with someone experienced and negotiate those. And I feel if that they are enforceable long-term if done properly. It's just not an off-the-shelf product, if that makes sense. Okay, so, and I think that was Tom. Okay. This is the second time I've gotten this question because somebody submitted this in writing. So I think it'll be a quick one. Does the open space property tax rate continue after death? Okay, great question. Farm, ag, timber. I mean, what about all these things? Do they continue after death? I mean, do they continue if I sell the property to someone? So this is a matter of what the receiving party will agree to. So, for example, if I were to die, my farm ag property would pass to my daughter, and on that deed and the excise tax affidavit that would transfer the property to her, she would have to agree to the terms of the open space or farm or ag designation. And she does that by signing her agreement to do so. So therefore it transfers to her. She could decide, I want to inherit this and I want to take it out, and she would be free to do that if she wanted to. But it is more normal to think of that continuation passing down in our farming group, if you will. Usually that's pretty important to us, and we don't want that removed because that usually means somebody's carving it up and selling it. So hopefully that answers that question. And look at it as the property has a certain character. Am I agreeing as the person who inherited it to continue that character? I can't have open space, but then, build a restaurant on it. I still am going to have to live with those open space, rules. So hopefully, that helps. Okay, another really great question is, if I already have an estate plan, but the law has changed, are the old documents honored? And the answer to that is generally, yes. But I want to be cautious that I have become the old lady in estate planning. When I started in practice, the area of law surrounding aging and death, pretty much hadn't changed in 30 years. 40 years in some instances, really not a lot happening. The amount of changes that we have had in the last 10 years are just absolutely staggering. So, if your documents are at a minimum pre-HIPAA, or getting to 10 years since you've had an overhaul, they're honored, but do we want them honored? I think that's kind of a good rule of thumb to get a checkup. The other rule of thumb that is a huge issue right now is the medical profession has been dealing with a lot of trauma, and their patience on powers of attorney for healthcare is limited. They all have had to staff up with, how do we interpret these? Hospitals are now having to deal with all these legal issues under powers of attorney. So, you know what? Your will, you're dead. You're not around to see the consequences, but your durable powers of attorney, you are. You're at the hospital for a short stay or something like that. Those documents need to work. We need to be able to access your finances. We need to be able to handle things. A dead giveaway that your powers of attorney and your documents need to be updated, kind of as a little cheat, is if the documents do not kick in until 2 physicians declare you unable to manage your affairs, they won't work. HIPAA, number 1, a doctor's not allowed to release the information if the document hasn't kicked in. And number 2, the medical profession does not want the responsibility of saying somebody can't manage their financial affairs under the legal standard, which is different from the medical standard. So that's kind of a dead giveaway if you're looking through your documents or your parents' documents, or somebody you're in charge of, and it says 2 physicians have to declare them unable to manage their affairs. Can you imagine pulling that off in COVID? We're talking a huge challenge. But I just encourage you, to update given those criteria. If you have a taxable estate, meaning you're worried about estate taxes, then unfortunately, we are on a precipice here. The current law is in effect until December 31st of 2025. And the law changes drastically January 1 of 2026. So this could be a good time to kind of get your affairs in order and then understand what are those circumstances where I might need to update. And sometimes that's related to valuation. I feel that one of the things that I am experiencing right now, myself included, I am shocked on a daily basis as to what property's selling for and what property's appraising for, because it's crazy how much things have gone up in value, right? So if I'm sitting here and I have an estate plan and I think I'm worth under $2 million, and so I've done no tax planning because I think things are not worth that much, imagine the pickle I could be in, given that, on average, our land prices have gone up 25% in 5 years. That can really change what needs to go into your plan. Okay, I'm cruising right along here. Kurt, you can always jump in if you want to throw something else out there, or if you're seeing all the questions.
One thing I would like you to touch on, and this might be opening up a whole can of worms, but is the the value of placing forest land into an LLC as a vehicle for transference, pros, cons. Why would a forest owner, a small woodland owner, consider that, or why should they?
Okay, great question. And hey, Rhonda, thanks for jumping in there and helping me with some of these questions because Rhonda's good at this. Okay, an LLC. I am a big fan of LLCs for two reasons. Number one, it's a crazy world. And I love the fact that I can create a limited liability company. I can transfer my assets into it, and I can limit the liability to those assets. What do I mean? Well, I do not want to sell somebody a half a beef that's contaminated or bad eggs, and they die from salmonella or some awful thing, and then they'd be able to sue me and come and take my house and my retirement and all of my assets. So one of the ways I can compartmentalize the risk associated with land ownership or business ownership is by creating a limited liability company. I think that sometimes we think of it as ourselves, like a husband and wife owning property. Why do I need limited liability? I've got an insurance policy. There is no substitute for insurance. So I'm a big believer of that. Well, guess what? The limited liability that I have during my lifetime is great for me and my husband. But what if I have multiple children and I'm passing down land and they're supposed to own it 50-50? And when people are on a deed and they're 50-50, guess what? That asset can be sold to pay a bill, if you will, or a liability of the other person. So how do siblings feel about being on title with their sibling and their marriage or being thrown into that mix? So when I speak of limited liability, it's not just for you in the here and now, thinking that something could go wrong, but it's also for those that you are passing an asset to. Number two, in addition to enjoying limited liability, it is a blueprint for success for my later generations. So I've got a few kind of pet peeves that, I think my poor daughter has to suffer for all the bad beneficiaries I've ever dealt with in 30 years. But you know what? She is not going to leave our farm to her husband. She's not even dating this husband yet. She's only 22, but he's not going to own it. So one of the great things in my limited liability company operating agreement, I get to set the rules for my family. One of my rules, you had to be born from me to own it. Guess what? My grandma, who originally acquired in the 40s, the 125-acre farm, she didn't want it outside of the family bloodline. She has 4 children. They're all married. I don't think that's a big deal. Why can't I control that? Sometimes the only ones who have problems with it are the spouses. But that's a good example of my blueprint for success. I can put those rules in my LLC agreement. I could plan for the worst. I could hope for the best. I can set up all kinds of rules if one of the people I leave my LLC wants to get out of the LLC, because guess what? We never want our kids to sell the farm, but it might happen. Well, if it does happen, I'd like to control it. I'd like to say, all right, child who's going to leave the LLC, you're not taking down my farm. So you're going to get paid over 20 years. Here's the interest rate, and here's how it's going to be valued. So my children are not going to argue over what's it worth, how do we get bought out, And you know what? I'm dead. I know they'll be mad, but I don't care. My priority is I have a goal, which with my property is to keep it, I'd love to say forever, and to pass it down the generations. And so guess what? My operating agreement for my LLC, that's all that it focuses on, is all of those particular issues. So number one, I've got my limited liability in this crazy world where I do not believe people sue over me doing something wrong. I think people sue much more over the perception of wealth than anything else. Number two, it can be our blueprint for success as we pass down to our family members. But one of my favorite advantages can be how it can be used to assist in tackling an estate tax problem. Excuse me, it's one of the tools that we have available to help us deal with these escalating values of our land. And we could talk for days about LLCs because they're so amazing. And they generally speaking are a family's favorite device because they are incredibly flexible and enjoy the most favorable tax treatment of all of the devices out there that exist. We kind of have a saying is, you know, LLCs are like the best thing since sliced bread because of our ability to cater them to each and every family circumstance. So I'm also trying to multitask here and keep on track to make sure that I didn't get another LLC question. Okay. Anything you want to add there, Kirk? Because I was going to hit this other question that we've had come up twice, which is what's the difference between forming an LLC and using a revocable living trust? Okay, so first of all, a revocable living trust, there is absolutely no liability protection on a revocable living trust of any way, shape, or form. If we could all go out and create a trust and put our stuff in it and be protected from all liabilities, we'd all do it. And it would violate the too good to be true rule. So a revocable living trust is a very, very, very different device than an LLC. An LLC is a business creation and it is taxed different. It is literally different in many, I mean, almost every conceivable way than a revocable living trust. Revocable living trust typically has, in the basic form, has two features. This is what I need you to do while I'm alive. This is how you're going to run my assets. This is what you do when I die. There's no liability protection. It is direction and a wrapper around the things that you own. Another question that has popped up is, can you adjust and change your LLC? And the answer to that is absolutely. I look at LLCs as a creature that we want to keep on top of, because don't we all have the same goal? How do we get the next generation involved in wanting to be a farmer and wanting to perpetuate forest land ownership? Well, we've got to teach them. We've got to develop the bond with the land. We also want to teach them the prudent ways to conduct, business and what are LLCs. And we want to get them going on the business side of how do we manage these entities and what's the prudent way to conduct that business. So again, those should be adjusted. And they're like other documents where you're going to want to keep on top of them given the family situation. Good example would be, I had a LLC and there's 7 kids, but there's 129 at the next generation. And so we decided that there was going to be an overhaul of each of the family lines were going to vote. So each of the 7 almost little independent families had to come together and make a decision. And they had a spokesperson for each of the 7 families. Well, what a great idea. Guess what? Grandma and grandpa didn't think about that because they didn't think about having that many people. So again, you'd want to keep that updated, and you can update that just like you would anything else. So I think that's where we were going with the adjust an LLC. If you were asking also, there is, while you're alive, many people gift LLC interests, which can have huge tax advantages, but that could be considered an adjustment as well. Or I could sell my land in the LLC. It's really no different than if I own it myself. There's another question that says, how do you transfer the forest land into the LLC? And this is very important because the IRS has a lot of these problems pop up. The only way to transfer the forest land to the LLC is a deed. You must legally transfer it, just like when you bought a house or you sell a house. The way to transfer property is via a deed. And when I started in practice, it was $2 to record a deed. It's now $100 for the first page. And I mean, about $250 just to record a deed nowadays. So it's not a trivial expense, but it has to be done. The legal owner of the property has to be correct, or your insurance is not effective. So it's not like we create an LLC and then we kind of just want it to be in the land. We actually have to do that legal transfer, which that comes back to our legal proof and kind of gathering all of our assets. And sometimes that can be a problem we uncover is somebody had an LLC, but they forgot to transfer the property to it. Okay. Kirk, you want to jump in here? I know we're down to 5 minutes.
Well, I think with the last 5 minutes, just for the sake of a little bit more dynamism with the group here, if anybody would like to unmute and ask a question verbally, or ask for any clarification on anything that Cynthia's already covered, let's give a few minutes to that opportunity. And if nobody speaks up, I'll just let
and
Cynthia
you guys,
keep talking.
I know a lot of you. I'd love to see your faces. And my screen, I've got almost everybody has theirs turned on. But I know lots of you would like to say hello, Merry Christmas. And for those of you that aren't local, I'm wondering, how am I going to get home tonight? I can't believe the snow. So somebody give me a question, a real person asking a question. Hey, Rhonda, good to see you. And thanks for answering and helping.
You're welcome. So I was really curious about this valuation issue to reduce estate taxes, which the LLC is great at doing. Is the conservation easement going to also help in that regard?
I believe that the conservation easement can help with taxes. I think that can help with estate taxes, and there's also some wonderful opportunities to plan to also use those to avoid income taxes during lifetime. So lots of times when I get a conservation easement project, I try to anticipate a 3-year window to plan to be able to eke every penny I can out of the government, because the underlying concept of the conservation easement is born out of tax. And so it follows where, you know what, yeah, we want the conservation easement, but let's also hop on that bandwagon and get some of the tax benefits. Again, those can be an valuation at death, but they can also be an income tax break while you're alive.
Thank you.
So, and I'm a big fan. I'm just not a fan of off-the-shelf conservation easements.
Anybody else have a question or want Cynthia to clarify something she's already talked about?
Howard LLC's tax just came up, and LLCs are taxed like a partnership. and they enjoy the best tax treatment of any device, any business. And if you're a husband and wife in Washington, you do not have to file a partnership return because you're considered one person under community property laws. But this is why we like them. And for you old timers, does everybody remember the 70s and the cattle operations and the cattle partnerships everybody participated in to get losses? Okay, and then we had Reagan come in and we lowered our tax rates off of 72% down to 39. We still have that partnership tax law. That's why we like LLCs, is because the taxation of LLCs is partnership tax, and it is amazing. And it's very fun to manipulate and plan with. Yes, I'm a tax geek. I love taxes. And I love saving taxes even more.
Question.
Annette had her
Uh,
hand up, I
Annette-
think. Oh,
Yeah,
sorry.
Annette Shipman?
Okay.
Yeah. Hey, I was wondering, I remember when we got the property, purchased it from the family, and we had to go through and get all that form filled out for the forest taxation bracket. If I die and leave it to my son, will he have to go through the whole thing all over again? You know, where you go to the, do we lose the forest taxation bracket when I die?
No,
Answer that
if-
quickly. And it's like Cynthia said, you have to opt into it, but to maintain the designated forest land, you have to let the county know that you want to maintain that, and you typically have to update and submit a new forest management plan
Oh, you
in
do?
order to ensure that continuance. I do those plans all the time. So when properties change hands, folks come to me and say, we want to maintain the DFL, the designated forest land tax status. And the county is requiring us to submit an updated forest management plan. So you cannot continue forward with that designation with the old forest management plan. You do have to update it and submit a new one.
And Kirk, I really think that I'd like to add to that is, you know, in the olden days, that really got enforced minimally, and some counties were openly, yeah, we're not enforcing that. Now, that is enforced.
Thank you. Yeah.
Let's take one last question, and I really want to respect Cynthia's need to get a home under the snow here. Bob, I see you've had your hand up for a little while.
Thanks, Kurt. I'll try and reduce the 2-hour conversation into the 15 seconds we have left. So our situation, testamentary trust, came into effect late in the last century. And now my brother and I are looking at making plans for the next generation for all the stuff that Cynthia's been kind of talking about. How does having the forest land currently in a trust affect our thinking about converting to an LLC? And I guess just throwing out it's in a trust and we're interested in an LLC. What advice would you offer for us?
You know, I think that's a really great question, because I think it's easy at first blush to say, oh, it's in a trust, and so I might not have the ability, you know, to do anything with it. But it is possible for the trustee or trustees to create an LLC. Trusts have the same concerns about limited liability and about taxation. And sometimes if you're using an old testamentary trust, I mean, there can be, you know, benefits to using an LLC. So I don't want you to dismiss out of course that you can't create an LLC. A trust can, you know, just like if I passed away, put you in charge of my farm, but left it in a trust until my daughter was 40 because she's not mature enough. You could say, well, goodness sakes, I think we better create a limited liability company, because every time I go to the property, there's people cutting branches and taking trees and quadding around and riding horses on the property. And I need to have limited liability, right? That's one of our common concerns as landowners of large holdings is we don't know what people are doing on every corner of our property. So you may still be able to create that and incorporate that into your planning. So how's that for 30 seconds?
So, and with the property being located in Oregon, that's a question for an attorney practicing in Oregon, correct?
It is. And quite
you.
frankly, I do want to tell you, there is a lot of interplay in Washington and Oregon these days, because there's some wonderful opportunities. People have been using Washington to avoid Oregon taxation by using LLCs. And in Oregon right now, you can only pass $1 million estate tax free. Do you remember when we talked earlier, we here in Washington, we get to pass 2,193,000. Good example of how every state's different. And right now, Oregon and California are the poster child of the worst places in the nation when it comes to taxation. I think we all knew that, though.
Yeah.
And that was like
I'll
48 seconds.
I'll presume to speak for everybody, and thank you and Kirk for your time this evening. Thank you so much.
Well, and I hope everybody feels like they learned something. I am in Tumwater right now, and I live out on Delphi. Is it been snowing out there? Is anybody out in the Delphi area?
Well, I looked outside in Lacey and it's melting on the street as fast as it falls. It's building up on the grass. So I don't think the roads are going to be affected.
Well, I did run home before the speech to do chores because we already had like 2 inches out there and it was like crazy, but I can't see out the window. Well, and I don't want to keep everybody either. I had a great time. I look forward to all of you that I know running into you, and I would wish everyone a Merry Christmas. And hopefully you're out cutting all your swags and wreaths from your own place. That's another benefit of being a timber owner.
Indeed. Thank you, Cynthia, so much. And to everybody, again, this Fireside Chat was recorded and will be put up on our YouTube channel within probably a few days if you want to review it or share it with somebody else. So once again, Cynthia, thank you so much for joining us and taking your time. It was wonderful and spot on. So